Hi, it's Mike DelSignore, Massachusetts OUI lawyer. In today's video, I want to talk about what happens if you're charged with OUI in Massachusetts, but you have a Connecticut license. So if you have a license from another state and Connecticut included, every state has a law saying that if you're charged with OUI in Massachusetts, the penalties will be the same as if it happened in the home state, for example, Connecticut in this case. So typically, Connecticut, I haven't seen suspensions on the administrative. So if you took a breath test and failed, I haven't seen suspensions on the 30 days or even on the 6-month refusal suspension. But what I have seen is if you take a continuance without a finding or certainly a guilty, you're looking at a 1-year suspension with an interlock device. So you can get an interlock, you can get back on the road, but you're going to have the interlock for 1 year in Connecticut. To get back on the road, essentially. So consider fighting the case. Continuing without a finding doesn't really help you in Connecticut anymore. It used to be that that wasn't considered a conviction. The law has changed in Connecticut. So I would recommend strongly considering fighting the case. A lot of people who have Connecticut license, you might have an OUI in Dudley, Worcester, but it really can be anywhere throughout Massachusetts. But those are probably the most common courts I see people with Connecticut license in. So keep in mind, in Massachusetts, there are certain laws that apply to OUI that if you had experience in Connecticut with a DUI, it's very different here. First of all, we don't use the HGN test. So you might have done an eye test. The police officer probably waved their finger in front of your eyes. That test is not admitted in courts in Massachusetts. There's a case called Commonwealth versus Sands where our Supreme Court said officers don't have the experience of eye doctors to make an intelligent analysis of somebody's eyes. So an OUI is a crime of opinion. It's a misdemeanor for a first offense in Massachusetts, even a second offense. It's still a misdemeanor. It's only a felony if it's a third offense. But these are crimes of opinion. They're winnable cases because the evidence, the field sobriety test, there's a lot of reasons why somebody may not be able to walk and turn or may have a misstep on those tests unrelated to alcohol. Could be the weather conditions, could be the footwear you're wearing, could be medical issues. So could be the way the officer's explaining the test. So there's a lot of different reasons why those tests may not really show impairment. I had a trial this week. The officer acknowledged on the stand that some people probably can't do the one-leg stand no matter what the circumstances are. So there's a lot of different strategies and ways to fight these tests in court that I've used throughout my years of doing criminal defense. And I'd be happy to share those with you. Go over your police report and help you decide what you should do in terms of whether you should resolve the case or try to fight it in court. If there's a breath test, it's not automatically admitted into evidence. So there's ways we can get the breath test excluded from evidence so that the judge or jury doesn't know about the results when your case is called in court. So there's a motion prior to trial called the motion in limine to exclude a breath test. If that's allowed, then at trial, those results won't be considered whether the trial is a bench or jury trial. So consider fighting a case even if there is a breath test. Sometimes I'll put the case on for bench trial and try to get the judge to exclude or eliminate the test prior to trial, not consider it. And our judges in Massachusetts, I trust them. If they exclude a breath test, they are the type of judges that can put that aside and won't consider that when deciding whether the government's proved the case beyond a reasonable doubt. So with an OUI, there's 2 ways to prove the case. 1, that you were impaired. 2, that your breath test was over the legal limit. So if you have a Connecticut license, your first court date, it's going to be your arraignment. It's not going to be a trial. You'll enter a not guilty plea, get a further date. You want to make sure you seriously consider fighting the case for a number of reasons. It's a subjective case. It's a crime of opinion. It's easy to get arrested. It's hard to convict. It's proof beyond a reasonable doubt is required for a conviction. But to arrest somebody, it's a much lower standard. So on the side of the road, the officers did not have to prove this beyond the reasonable doubt. They just had to have enough evidence to satisfy a standard of probable cause. It's a much higher standard in court. So if you want to call me, text anytime. Be happy to discuss your case. My name is Mike DelSignore, 781-686-5924. My passion is helping people charged with OUI make the best decisions for themselves, and I'd want you to hopefully fight your case, win your case, so you can preserve your license both in Massachusetts and in Connecticut.